Hi, I'm Rebecca Kern, a tech policy reporter at Politico, and welcome to our CCIA Research Center event today on how narrowing Section 230 could crash the digital economy. We'll be speaking with a panel of experts on this topic, and each of them will provide more of a bio to you, but just to introduce, we have Ginger Jin, a professor of economics at the University of Maryland, Sarah O. Lamb, a senior fellow at the Technology Policy Institute, and Laura Babesto, head of policy, privacy, and regulatory compliance at Nextdoor. So each of you could tell us just briefly a little more about your bio, and then we'll jump into the panel.
Hi, I'm Laura Basesto. I oversee policy and privacy and regulatory compliance at Nextdoor. I founded the policy program here and oversee the public policy work as well as the content moderation program. Before joining Nextdoor, I was at Lyft and Verizon Media, which prior to divestiture owned Yahoo and AOL. And before that, I was a criminal prosecutor in San Francisco and San Diego counties.
Maybe I can go next. I'm Ginger Jin. I'm a professor of economics at University of Maryland. Most of my research focuses on information economics. I have served as a chief economist for Federal Trade Commission in 2016 and 2017. And I'm interested in Section 230, partly because my research interests in information economics, and partly because I have filed an amicus brief to the Supreme Court with some fellow economists.
And I'm Sarah O. Lamb. I'm a senior fellow at the Technology Policy Institute. I'm an economist and lawyer. And with my colleagues, we also filed an amicus brief in the Gonzalez case as economists.
Thank you, guys. Well, I wanted to kind of start off. Obviously, the Supreme Court arguments happened in late February. We don't exactly know when a ruling will come, but I guess since two of our panelists filed amicus briefs, I wanted to just see where each of you laid out your positions going into the arguments, and then we all can kind of talk about our views of where we foresee maybe the court heading. If Ginger or Sarah want to just lay out where you and also Laura, feel free to chime in. But since two of you wrote amicus briefs, I thought I'd pool your knowledge here.
Okay, maybe I can go first. I think Section 230, immune protection for digital service providers, is a backbone of internet services, and we would not see as much innovation and content and new product and services without Section 230. So I think a narrowing of Section 230, especially in the form of Supreme Court judging on a particular case rather than a federal law, would have the danger of reducing the incentive for future innovations, and also make the current internet services not as viable.
And for our amicus brief, I'll just give a shout out to my colleagues Scott Walston, Tom Leonard. We also filed with Jennifer Tatel, Jonathan Cohen, and Morgan Schick. So the purpose of our filing was to bring an economist point of view to the justices and clerks on the court. You can imagine, they're hearing cases about everything in the law, and they're not steeped in Section 230 and the internet. And so we wanted to just highlight the importance of targeted advertising to the digital economy, how free services such as email, search, and video content are powered by advertisement revenues, and how targeting is really a two-way flow of data between the user and the server, and it creates efficiencies. But it can also, as the petitioner said, could be algorithmic and create outcomes that are unexpected. And so we also wanted to highlight just the statistical nature of recommendation engines, how bias is measured and remedied. So the economics literature is actually pretty full of studies that kind of track the statistics. There's just so much data flow and algorithmic activity that it's not always like intentional that there is bias or that certain topics get recommended. And so I think in all of that, I and my co-authors, we wanted to just show that this exercising of defining and drawing lines on algorithms is not as easy as it might appear to be. And so if the court were to lift that safe harbor or immunity shield, you would see a lot more like courts getting flooded with litigation and fact finding on that motion to dismiss stage. Whether the Supreme Court wants that to happen, or or thinks that it's out of its jurisdiction, that's up to them. And I have a point of view on that, but I think they need to understand like what that would mean and like how broad a change would affect like not just the big websites but small websites, and just how this is kind of a technical journey.
Laura, do you want to weigh in kind of on how Nextdoor took a position, or did you guys before the arguments?
Thanks. We're part of a coalition called the Internet Works, which represents small and mid-sized tech companies in Washington, D.C. Other members include Pinterest, Etsy, eBay, Reddit, TripAdvisor, a number, as I said, of just the small mid-sized platforms in the U.S. And they filed a brief in the case, which talks about the risks of amending Section 230 to these small to mid-sized platforms and the impact on them, which would be very detrimental given the outsized resources needed to deal with the litigation that Sarah was talking about.
Right, exactly. And so we watched the arguments. Now we've had 6 weeks to digest them. And I wanted to get your initial interpretations and, where you think the court is heading. Do you think there will, maybe rule in a narrow fashion and in potentially rolling back some of the Section 230 protections? For those who didn't watch the arguments, in summary, the case before them is a lawsuit filed by family members of an individual who was killed in a terrorist attack, an ISIS terrorist attack in 2015, and they've sued Google's YouTube over what they say is the use of the algorithms to promote terrorist content. And the question before the court is whether Section 230, which is the liability shield provided to internet platforms, whether that covers the use of algorithmic recommendations or targeted algorithms, and whether that in itself, the algorithms have these protections. So, we all watched this case play out, and we had plaintiffs argue that these should not be protected, and then we had Google defending the use of the algorithms. So I just wanted to see, where you think the court may be heading, and we could talk about, each outcome, but just getting your initial interpretations, I guess.
I'm happy to kick it off. I think it's really hard. First of all, I just want to say it's impossible to predict what will actually happen. But what was really interesting is just the significant level of confusion among the justices when asking questions about the cases and the lack of, I'd say, clear answers from the parties as well about where this was headed. There's been, months, years to prepare for this. And it was kind of interesting to hear just the level of, lack of direction, I think, from different sides here, what they actually wanted, including the justices had just a number of of questions. And these cases were granted. Was it a good idea to grant these cases? I'm not sure, but I think that's a really interesting question. And what's interesting about the two cases is the Gonzalez case has to do with Section 230 directly, algorithmic amplification. And then the Twitter v. Tamna case has to do with the Anti-Terrorism Act and whether there's enough evidence to show that by Twitter showing these ISIS videos, and not necessarily the one that was tied to the Terrorist Act, whether they had sufficient knowledge to be liable in this anti-terrorism case. And the lower courts had skipped the Section 230 debate. So that's kind of interesting. You have these two very similar cases, different issues. I mean, ideally, for my purposes, I'd love to see in the Google Gonzalez case, the lower court affirmed, meaning Section 230 applies. And then Twitter case would be remanded to evaluate the case for Section 230. I think that's a realistic option after what we saw at oral argument. But, you know, there's other options as well. In the Twitter case itself, they could say there wasn't enough knowledge. And in that case, I think you could remand the Google case and also get rid of that case for that reason if there's not enough evidence of knowledge to go forward, because the facts in Google are similar in that sense. So I think those are some options Nextdoor would like to see, but I can't predict exactly where it's going to go, but the questions were positive, I'd say.
I also, watched both days of hearings, and it was really interesting to listen in on how the justices asked questions and how much they understood or followed Section 230 jurisprudence. And there are some well-known quotes, like Justice Kagan said, "We're not the 9 greatest experts at the internet here. Why are you asking us to weigh in on such technical definitions?" And there was confusion as well. Like the advocates were talking about thumbnails and different icons and, going into technical but creating some confusion because thumbnails wasn't briefed in the pleadings. And so that wasn't really a part of the argument. And so, like Laura said, you could see that there was just kind of a lot of exploring happening in the oral arguments. And it wasn't quite a tight, linear progression discussion. But I think that might indicate also that there is a divide between people who are understanding algorithms and how these systems work, and then people who are, interested in institutions and how litigation works and how the courts are functioning. And so there is, I think, good questions about institutional expertise. Is it for Congress to decide these policy trade-offs? Is the burden on technology companies to explain themselves better, to be transparent? Is the burden on I don't know, I guess economists like us to describe how important the sector is? And so I think it raises a lot of questions about just technology and then legal systems.
I echo the impression described by Laura and Sarah. My impression is that seems like discussion is much broader than the particular case. The discussion is not on sort of exactly what's the causal link between, say, the ISIS video and the terrorist event and the harm out of that. It's more on the broader discussion of whether the immunity offered by Section 230 should continue, and how algorithms or what type of algorithms might be relevant or irrelevant according to the original interpretation of Section 230. So I think that broader discussion, as Sarah indicated, seems to be more appropriate to be discussed by the whole society, or maybe in the form of Congress legislation rather than by the Supreme Court, starting from a particular case, but try to really broaden the coverage way over the particular case. That's my impression.
Right. And a question we have that before us is whether a narrowing of Section 230, wherein target algorithms or recommendation algorithms are not protected, and therefore companies using them could be potentially held liable. What impact could that have for the digital economy and that sector? And we could break it down into differences between impacts on large tech platforms versus smaller, mid-size, and then even startups. So if the court were to rule in some manner in narrowing the interpretation of Section 230, what are some of those implications on the business sectors?
Since I work
first, yeah, I see your company on the panel here.
So Nextdoor, just if people aren't familiar with it, is a platform where you connect to neighborhoods that matter to you. You've got neighbors, you've got businesses, you've got public agencies, and you're all connected based on proximity. You use your real name, use your address to sign up. And importantly, we have a community moderation model where the community is largely responsible for moderating a lot of the content. And we do that because we want the community to be able to, the voice in the community reflect what is online as well. So we have some unique features, and we see them as a competitive advantage, frankly. And we're concerned that any narrowing of Section 230 could, first of all, risk the ability for the community to moderate. One part of Section 230 is that the community or that users are able to take down otherwise objectionable content without liability. So that's one issue. But in terms of the algorithmic amplification, I think you can see, a disproportionate impact on smaller niche companies that use algorithms to curate the types of content. I mean, for Nextdoor, we want to make sure you're seeing relevant, very hyper local content that's very timely as well. That's very important to us. A missing dog is important in that moment. It's not important 2 weeks later. So it's really important to us to be able to continue to use algorithms to provide useful content that's relevant. And any narrowing of Section 230 could really impede that ability on both sides, on the removing content, but also the promoting of relevant content. And there's been nearly 30 years of Section 230, 27 years, and it's allowed incredible American businesses to grow that have these very niche areas. And of course, everyone focuses on the big tech platforms that really are all-encompassing, but they forget a lot about these small, mid-sized companies that have these niche offerings that are highly competitive, successful businesses.
Rebecca, to answer your question, I want to remind everybody that we see the past 2-decade or 3-decade development of internet services because of two fundamental economic forces. The first is technology had advanced so much that the mass communication between everyone is possible and much cheaper than before. This could be local communication, as in Nextdoor. This could be global communication between any two persons on Earth. So that's number one. And number two is because of this lower communication cost, consumers face massive information overload. And just to give you a sense, that's in last year, we observed like 500 hours of videos uploaded on YouTube every minute. Okay, so that means this amount of information is just impossible for consumers to choose and consume without an algorithm to sort and list, right? So I think these technology changes and the consumer information overload is the fundamental reason for why we get to where we are today. So this means some algorithm selection is a must. If the narrowing of Section 230 will provide the narrowing because of algorithm use, I can imagine big or small firms could have two reactions. One is you just completely give up algorithm use, okay? And that would sort of probably make you safe in this Section 230 protection because you're not using algorithm. However, this could be very difficult for consumers to find what they want, which would undermining the viability of the internet business themselves. The other reaction could be they are going to tweak the algorithm in a way to minimize their liability. This could mean that they are over censoring contents that may have any potential of generating controversy or misinterpretation. But either way, we're going to see maybe less content creation and less content consumption and less business available to match the demand and supply of such information need. So I think this will be a dire situation, in my opinion, and would reduce the economic benefits the internet has brought to many players.
Yeah, and I think in terms of big and small companies being able to defend themselves against litigation, you can just imagine that the cases, the fact finding would go into, like recently, I guess Twitter open sourced their algorithm for recommendations. So Elon Musk made the Twitter algorithm public. And so you can see all the weights that they add to tweets and how different tweets are amplified differently. And so it's really interesting to see, oh, it depends on how many followers you have or how many likes or retweets. And there's a certain number attached, like 0.6, 0.2, 0.11. And so you can just imagine like that exercise where, an algorithm that has a set of weights is amplifying certain material that, might generate more clicks, but is determined by like a weighting system, but not an intentional. I mean, there were some like hard-coded like buckets in the Twitter algorithm, like tweets by Elon or like, certain blacklists. But other than that, the algorithmic amplification is as a statistical exercise. It's a weighting system. And so, you just have to imagine that the tort cases would be, about, well, what's the causal chain between this weighting system versus a different set of weights, and it just gets complicated, and not to say that it might be worthwhile for that to go through litigation rather than a policymaker making up rules. There is like good fact finding through the litigation process, but just the sheer scale of it, every website, every internet company that collects user generated content and distributes it would be now open to a lot of litigation. And then, maybe it would be a waste of the court's time, or you'd have to really put more resources into that kind of exercise. So I think it's important to think about just the scope and the scale of these data services and what those kinds of remedies would mean.
And wanted to speak about what would the impact be on how companies moderate content, because platforms we know use algorithms, as you're all kind of alluding to rank content or to prioritize. They also use it in the reverse to take down, to automatically they'll flag certain words and hashes to remove immediately before a human moderator even intercedes. So just speaking, I mean, if Nextdoor wants to talk about how you approach content moderation, or at least the industry it approaches the use of algorithms to moderate content, and what as a result platforms may, or internet companies may choose to do. I know Ginger alluded, like, may either just leave it all up, but then we get to the issue in Twitter v. Tomno where we could have a lot of terrorist content on the platform if they choose not to use these automated algorithms to take down certain content. So I'm just kind of alluding to could this backfire in the end if the intent was to take down certain harmful content with the use of algorithms, but if you can't use them at all, how will the court maybe thread that line? I'm not sure, but maybe you guys could imagine.
My colleague describes the situation as a cesspool or Disneyland, scenario. And I don't know, for Nextdoor, that's not necessarily true. We're a different platform because of our verification, community moderation, and just the nature of being connected on a very small scale with neighbors. We don't have the kind of scale of harmful content that we're talking about anywhere else. But I can imagine that there's a disincentive, as Ginger was saying, potentially to even apply an algorithm at all to remove content. I mean, one of the beauties of Section 230 is that it incentivizes companies to be do good and try to make their platforms a place, from at least even an economic perspective, where people want to be online, and it without liability in it. You're able to test things, and if you miss something, it won't, destroy you in litigation. And so this sort of puts that at risk. So maybe it's not worth doing anything, and that would be the potential cesspool situation for certain platforms that have that kind of content. And then there's the over moderation as well, which is really harmful for free expression and for especially groups that are cultural minorities or dissenting viewpoints. I mean, that could be really harmful if you have an overly moderated platform as well. And really, it just takes away the ability to have these niche businesses that kind of want to curate content for you, that want to have just very much content that's related to that kind of model, to go there to get that kind of, to have those kinds of conversations. So I think it really takes away from that fundamental idea. And I think there's a real policy disincentive underlying this as well.
Yeah, I feel like there are kind of two potentially separate discussion here. One is sort of bad players try to take advantage of the intermediaries. So the contents they provide, we probably, at least the majority of the society would agree, they're bad content, they're illegal activities, and they shouldn't be discouraged or eliminated. The other discussion is about sort of maybe different opinions on different things, right? And that's sort of fall into maybe the free speech First Amendment bucket. And I feel like the two often got conflated, but they're really distinctive issues. For bad plays, Congress have acted by having a law really make the digital platforms liable for, say, sex trafficking, right? And arguably, that's one way to narrow Section 230 protection on digital platforms. So I think there is a way to narrow the Section 230 in the areas that focus on bad play, illegal activities that we as a society agree that we should really discourage and eliminate, and we should clarify the liability of digital platforms or other internet service providers in the middle of that. I hope we can separate that discussion from the free speech discussion.
Yeah, that's a good point. And I know a lot of the conversation going into the arguments was a lot of, some may have said, boy cry wolf, like the internet will break if, we narrow 230. But what Ginger just referred to is an example of how Congress did narrow the law with Sesta Fosta passing and enacted into law in 2019 that cut out immunity for platforms when it came to sex trafficking on their sites. So do you all feel, I feel like you've all kind of indicated, and even some of the justices indicated, this is actually the role for Congress, not the Supreme Court, to weigh in. All the the court can do is interpret, I guess, the language differently. But where do you see Congress stepping in here? Ginger posited labeling certain bad players or illegal activities should be more discreetly cut out from liability protections. That could be, if that's the intent of these taking up these cases to go after terrorist activity, maybe that would be the route. But do you guys see any opportunity for Congress to act in a bipartisan manner is the question, where we have yet to see them act. We did see them act on sex trafficking. So, and there are some areas, I would say maybe child sexual abuse content has been an area we have seen some legislation being introduced. So just talking about kind of what role you could foresee Congress potentially stepping in and playing here.
Well, I think Congress will probably, pressure will increase for Congress to do something as the 50 different states are passing different statutes on content moderation. So there's become a patchwork in content moderation, similar to privacy. So biometric laws are also a patchwork across the 50 states. So you have two areas of kind of data legislation that Congress has to figure out, I think. I don't envy them. I think it's hard to imagine a point of consensus or how to come up with a federal rule that in either area, privacy or content moderation. Because for the cases that Ginger's talking about, the misinformation, disinformation, free speech area where there's no real right answer, how do you define that? And then really in the US system, it's the First Amendment. It's a broader standard. And so I'm curious to hear what the other panelists think, how Congress will respond.
I'm not sure the Congress can come to a consensus on how to deal with the free speech issue. But if the focus is on limiting bad plays, I see some hope, like the example in sex trafficking I gave before. There are also similar laws, say in money laundering, right? That's the banks are put on some liability for money laundering, and they need to do certain things to help limiting that kind of activity. I see some similarity between that and digital platforms' role in limiting bad play. I think the core issue here should be I think the liability first should be on the first party that provide that content. Okay, if the bad play content was provided by bad players, then bad players should be the first party liable for that. And then intermediaries like digital service providers, they're intermediaries, they're sort of a third party, but they may play some role in help disseminate that information to others, right? That's kind of the issue. And you want the law to somewhat provide incentive for them to help the police, to help law enforcement to catch those bad guys, not to sort of kind of making themselves liable with a very blanket law. I think the law should be sort of articulate and like exactly what the digital platforms should do, right? Like, should they collect certain information about the identity of the content providers? Do they need to confirm the contact information? To what extent they should sort of monitor the content and track the identity and make sure the law enforcement would have access to those information so that they can sort of do their law enforcement as quickly and timely as possible. I think we should think of this as incentivize the digital intermediaries to help eliminate the bad plays, not to just sort of either put them in the middle as if they are the main or sole liability party, or just completely sort of brush them aside. I think either way is probably not a good solution here, given how things has been taken advantage by bad players in some intermediaries. So I do have some hope in that if the two parties can sort of narrow and agree to focus on that.
Just to add on, I mean, there's fundamental disagreement on, generally speaking, on the right side, the Republican side, they want more content to stay up. The left, the Democrat side, wants more content to come down. I think the question is, will they be able to meet? I'm not sure that's going to happen in the 118th Congress, to be fair. And I think there are concerns about even the legislation. I think some of you are referring to about taking down more harmful types of content. I think there's potential Fourth Amendment concerns with requiring companies to search for content and hand it over to the government. That's absolutely a Fourth Amendment concern. So I think there's probably concerns up and down that haven't been considered yet, but I think Congress is the appropriate place to look at this. at this issue. They drafted the law, and I think if it needs to be changed, they should be the ones to look at it. I especially believe that as we're starting to see a patchwork of state regulations evolve. And I would predict that ultimately the companies and others are going to Congress asking for help in this area.
Right, exactly. And one interesting amicus brief we saw was from Reddit, highlighting that Section 230 actually protects users as well as the intermediaries. And so I wondered if Laura could weigh in too about how if the ruling were to narrowly interpret Section 230 where algorithms are not fully protected, how does that impact, like, say, moderators on these platforms who are lay users often? I don't know if Nextdoor uses community moderators. That is the setup for Reddit and other platforms too. So I don't know how often the user conversation is brought up too, but they could be held liable to a lot of lawsuits. And unlike large platforms, I mean, that could be extremely detrimental to them. So I just talking to the other end of the impact of rolling back on the users.
Yeah, Nextdoor, like Reddit, has community moderators. On Nextdoor, we have over 200,000 moderators around the world, and they actually help remove 92% of content in a median time of around 6 hours. So they're really fast and efficient, and they're all very much based in their local communities, and they're moderating content in their communities to make sure that the community reflects the tone in the real world and online, that they mirror each other. And that's for general content around civility is really this higher standard we have on Nextdoor, because we're connecting people that don't know each other. We want you to be able to have civil conversations. So that's really primarily what's being moderated by the community. But as you said, and as Reddit has argued as well, Section 230 protects the community moderators from liability for being able to review content and help determine whether or not that content should be moderated. And that's actually, for us, we believe, a competitive feature of our business model. And because of it, we think we are different. We're different from the big players, and we have a different offering. So actually changing that part of the law could really negatively impact our competitive model. And I think, again, empower the big players, when I know a lot of the attack is at them, but there's really unintended consequences for the smaller players if you take a one-size-fits-all approach here. And I know Reddit has talked about that as well, where they have their subreddits are moderated by the people in those groups as well, to have very niche topics be the conversation. That I know I hear them talk about a group for cats. They only want to have people be able to talk about cats, and their moderators should be able to moderate for that. And so on Nextdoor, it's similar. We want our community to be able to moderate for this civility standard and what matters locally. And so we're really worried about that impact, and ultimately that the competitive nature of our platform because of that, and that going away.
Ginger or Sarah, do you want to weigh in on some of the economic impacts there? I mean, and what Laura was kind of saying was kind of leads into another question, is just like, how could a narrowing further entrench the larger platforms who could afford lawsuits and compliance if they were to have a much stricter enforcement regime, or would be subject to more plaintiff lawsuits? So that kind of plays into the economic factor here, and wanted to talk to you guys about the impact this could have on the competitive nature of the digital economy.
Yeah, definitely. I see the compliance costs. I suppose there is some version of narrowing of Section 230, and there is a flood stream of lawsuits. I mean, startups often have less resources than the incumbent large players in the market, and their survival probably is online, depending on sort of how costly a lawsuit is. So in that sense, I'm sort of worried that not only the startups may not have enough resources to develop new products or services, they could not even able to survive or even try to enter the market because they anticipate a very high uncertainty and lawsuit cost. So in that sense, it's going to is going to harm the competition in the market. If nowadays there's some resentment about sort of the market power of certain incumbent platforms, and if we hope the market competition could be a part of that solution, then this higher costs may undermine that as a potential solution to that problem.
I think we haven't mentioned yet today AI and the algorithmically created content, and so you can imagine that there might be platforms that are full of just curated content, like synthetic media, and I suspect that there will be a lot more artificial content. Like you just look at Midjourney or like some of the movie making applications of GPT-4, you can make full-on Pixar films just through the algorithm. And so as technology changes, companies might feel like it's not even worth it to ask users to contribute third-party data anymore. We're just going to create it on our own. And so, you don't know what the future is going to hold. Like maybe if there maybe user-generated content won't even be that big of a percentage of the internet. If AI is really generating a lot more content more quickly, you're gonna see curated content. And so I it's hard to predict like the way the internet will grow, where revenues will come from. But I think the point being, like, if lawmakers make rules based on today's internet, that'll shape the way the internet evolves in the future as well. So, and I think there are good questions about like, well, what would a rule change look like for a metaverse environment? What does content moderation look like in an AR VR environment? Although even that was like a hot question 2 months ago. But it seems like not such a big deal because it's like, oh, metaverse is not happening yet. Like that GPT-4 world is happening instead. So, and then even, like, oh, maybe Chinese companies like TikTok, maybe that's the bigger threat than like our homegrown companies. So like all that to say, things are evolving quickly, and like making rules that really fundamentally shift the ecosystem's incentives would have big effects. And I think that's why Congress can't really come to consensus on it. It's just a hard problem, while recognizing that bad content is bad, but designing rules and laws that might have bigger effects. And especially, 9 justices, like, I don't know if that's the institution you want making rules about the internet. So big questions.
Yeah, we're all posing a lot of the questions. Another big question kind of posed by Justice Neil Gorsuch, which kind of Sarah did a good preview to, was questioning whether generative AI text gets Section 230 protection. And I know there's been several kind of law articles written since he said that, and we don't know if he'll even do any writing on it as part of this opinion. But since you started that conversation, Sarah, like, what do you think? How do you think that content will be protected? Since Section 230 is technically just third-party speech that gets protected, and not necessarily the platform speech, yeah. Do you want to weigh in, Sarah, or how do you guys think? What do you think about whether that could get protected?
Well, I think, a lot of the discussion about Section 230 goes back to what was the intent of the writers, the co-sponsors of the bill at the time. And so at the time, it was to promote innovation and a free enterprise for internet companies. And so similarly, right now we're at a moment where we're talking about AI policy, and there have been some calls to like put a pause on growth, or let's figure it out first, or it could be just. And so it kind of seems like a similar moment. Do we want to see innovation explode or happen, and keep a light touch approach, or are we going to put a stop on it? And so I think that while there are a lot of like concerns, or doomsday concerns, the way reality unfolds, there are incentives for brands and companies to keep brand safety. So I think that too is like a force that we need to keep in mind. I don't think brands want to be known for being an unsafe environment, and that's even, they don't even want to be associated their advertisements with unsafe platforms. And so that is a real market force that I guess should be part of the conversation too. And just like Laura talked about, like brands wanting to be known for their content moderation culture or policies. So
I think Sarah makes a really good point about brand safety. I mean, I think that there's a serious market force in the competition for ad dollars to have a safe platform where brands can be assured that their content will not go next to content that's harmful. And so I think that absolutely needs to be part of the conversation. I think that Justice Gorsuch's statement, I think, it could be applied to a very narrow circumstance. I think there's going to be a lot of different ways generative AI is used by different places, platforms. It can be used in more of a search. It could be used more as an information content provider. I mean, I know you referenced the two articles, Rebecca. There's the Lawfare article where they say that it absolutely won't be protected. It'll be an information content provider. And then there's Jess Mears' response, where she fundamentally disagrees. I have to say, I probably lean more on the side of Jess Mears' most recent article on this, where I think she cites the Fair Housing Council of San Fernando Valley versus roommates case, where there's conversation about whether the website or the information content provider, whether to determine that whether they materially contributed to the content's unlawfulness, or whether there was some material contribution that would make them the information content provider versus just the intermediary. So I think that it will really depend on the use cases. I don't think you can just have a blanket statement about what it is or isn't. I also agree with Sarah as well, that when Section 230 was written, and it's so funny, we speak about it as though it's the founding fathers document at this point, but I think that's what we're looking at. They couldn't imagine where technology was going to go back in 1996. And I think this is definitely an iteration of technology that, they were technically accounting for when they were writing Section 230, these unknown possibilities that will create tremendous American growth and competitiveness. And so, yeah, I think it'll be interesting. I don't think the comments, though, would apply in every situation. I think there's going to be different scenarios that we haven't contemplated yet.
Yeah, I think generative AI, this is just the beginning of generative AI, right? We sort of see the technology itself evolve very fast in a month, and people have sort of a lot of thoughts in kind of the way of science friction. It's very hard for the legislation to predict what could be the potential harm and how can we prevent that today by having a law that may last 30 years. But that being said, I don't think we should, or the Congress should, aim for a law that very comprehensive, would cover the problem we see today, as well as the potential problem that could come out of generative AI in the future. I think if that's the goal, we probably will never come together for an effective legislation. So in my opinion, maybe we want to have some wait and see on how this generative AI technology would develop into business. But at the same time, we already see some problems like bad play, terrorist video, and other things that we want to resolve that problem, right? That's if the Congress can come together with some clarity on exactly who has what liability and how can we discourage such bad play. I think that would be a win for the Congress.
Yeah, and in the interim, we're just seeing, especially in Europe, Italy is banned ChatGPT. The UK's ICO has opened an investigation into it. So we've always seen Europe tending to operate first in terms of the regulatory pathway. And so maybe the US will watch and see how that goes before acting. Also agree. I think a consensus approach probably won't come about this Congress at least, but everyone's kind of alluded to the state laws that have passed that are content moderation based, Texas and Florida. They don't directly address Section 230, but it is directing platforms to keep up content, prohibiting them to remove user viewpoints. And as a result, NetChoice and CCIA have sued, and those are going to be lined up potentially for the court to take them up this fall. I'm curious how you think the outcomes of these rulings could interact or maybe operate in the opposite or in direct contrast with how the court may address those cases if they choose to this fall. They've asked the Solicitor General to weigh in so far. Because in theory, you could be preventing, platforms from removing using algorithms to amplify, but then, holding them back from, taking down bad content. So it's a tough one. I just, if anyone's watching those cases coming up in the fall and seeing how that could impact, I mean, it would be after this ruling, but just curious.
Yeah, but I feel like we now have like a patchwork square, right? We have one patchwork of different state laws, and then we have another patchwork of how the local court side with the laws. I think this is a nightmare for digital services who aim to serve national or even global customers, right? I mean, how to navigate through this patchwork square, it must be very costly, and that's just another reason I hope this kind of the heated debate would encourage the Congress to really consider a uniform framework for across all states.
Yeah, and I think Ginger brings up a good point. A lot of the big firms, they already manage global differences in content moderation policies. So you can imagine the big platforms, they know Irish law and UK and EU regulation, and they're in compliance, presumably. And they have, I bet, hundreds of lawyers who follow whether they're, following the laws of the country. And now, would they really be able to separate out their information services in Florida versus Texas? Is that even like something that small companies should be expected to do? But you can also imagine that, well, if in that universe, there would be a lot of companies that could manage or could create platforms that would handle all the different rule changes. And so, I think as an economist, do you really want social resources to go towards compliance and like overhead? And I mean, maybe, as a lawyer, it's like, oh, more jobs for lawyers, but, is that really socially beneficial? Or, is that a good use of resources versus like innovation and R&D? And then the backdrop is like global competition. So yeah, China, I mean, they're moving forward with their AI, and they're on the other side of Europe. Europe is very regulated. China is not that regulated, or at least whatever industrial policy, whatever the government wants, that's what they can do just unilaterally. So I think the US in terms of policy is kind of in between those two poles. Like we're a democracy, and yet, you know, we don't want to be like Europe. We don't want to be like China. What's the US way forward? And then also in terms of attracting global talent to innovate here, that's been like a policy goal, the Buy America theme, and so I think it's going to be interesting to see how Congress approaches the question of the patchwork that's happening at the states.
Patchwork is a nightmare for consumers. I think that's the point that I think a lot of people are missing, and a lot of legislators are missing, is that they're missing the point that a patchwork of 50 state regulations doesn't do a lot to help consumers that live on the border between two states. And for next door purposes, maybe they are their neighbors in both states. I mean, what does that mean? Does that mean you post, you have a lost dog example in Reno, Tahoe area, and you can only post it in Nevada, you can't post it in California? Does it mean states have to be blocked off somehow? It just doesn't make a lot of sense that you would have just 50 states of rules for these online communities that are supposed to be bridging all these state lines and bridging borders. So I think it's a little bit short-sighted to have so many different regulations. And that's why I say I think at some point we're going to have more and more. And again, as I said, on the right, the Republican side, you're requiring content up, and on the left side, they haven't said content comes down, but they'll be asking for more and more transparency around certain types of content online, which arguably is putting pressure on platforms to take content down. I think that'll be debated in the courts at some point. But I think ultimately you're going to see companies asking Congress to intervene at some point.
And that's kind of what I wanted to pull off from what Sarah and also what Laura's saying, just like the business impact on these global players. And if Congress or the court were to narrow 230 and lead to more costly enforcement and compliance costs, just as a last kind of round robin question, what impact would that have on innovation in the future in the digital economy? If these companies were having to spend more on compliance costs, if 230 were narrowed, wherein algorithms were no longer granted immunity, or if these state laws are moving forward. So just talking lastly about like the impact on innovation and startup and investment in that space, because we know we've, as Sarah said, metaverse investment is already going down, and that was supposed to be the future. So just speaking, about that.
Yeah, go ahead, Sarah. No, Sarah.
Oh, I'm curious to hear what Ginger has to say, because she's an expert at GDPR outcomes.
Thank you, Sarah. I can think of two effects. If we think most of the compliance cost is kind of a fixed cost, right? You have to understand the different laws, you have to understand different enforcement, implementation of the laws. If the compliance cost is fixed, it's a very large fixed cost, then for certain small startups, it's just impossible for them to swallow that cost and still remain as a business. So I think that selection effect is quite concerning. Even for the startups or large or small firms that is able to kind of take that compliance cost, there's also a substitution effect. They have limited resources. If they put more resources in compliance, it could imply that they have less resources for innovation of the next generation products and services. So that could be eventually detrimental to consumers and to competition as well. So both will be concerns.
I agree with Ginger. I mean, I think that's absolutely the risk here.
Any last words, Sarah? Okay, great. Well, we're just at time, and I just think we had a really nice, broad conversation. Obviously, none of us are mind readers for the Supreme Court, so we're gonna have to wait and see. But we'll all be watching and be talking about this issue going forward. And thanks everyone for their time today. I appreciate it. Have a good afternoon.
Thank you.
Thank you for having me.